All right, I'm going to go ahead and get started. I'm Dave Goss, here for the Collaborative Juvenile Court Stakeholder Convening, as we're calling it, with the goal of actually making progress so that as soon as possible, we have the disclosure issues resolved and we can all move forward with the appeals and the cases as we are hoping they can. So that is the purpose for today's convening. A couple of things. This, again, is not a public meeting in the traditional sense of a committee or commission of the Supreme Court. We're not going to be taking public comment at the end of the hearing, but folks are certainly, we want to invite the public in to know what's going on and also to make sure that we keep this process moving forward. I did send out an agenda for folks. The first part of the agenda is welcoming remarks, but the second part I want to comment on here in a moment. Judge Starring, unfortunately, is stuck in an airport, and Judge Young is stuck in court. So both of them are very busy, but can't be here today. I know that we have at least some folks from Division 2 who have logged on to watch what's going on for Judge Starring, and Division 2 is paying attention as well. The first thing that we want to go through as we're talking about this is unrelated to the disclosure issue, though it tags it just a little because of the stay issue and the affidavit. But a little bit of history, and I have two of my judges from my court here and my chief clerk who will be here in a moment. She actually ran up to get me the agenda because I couldn't find it online to talk about this new process. And the process involves dependencies. And what I'm going to be very specific about is appeals that involve an appeal from a dependency ruling and does not involve an appeal from a termination hearing. So I'm going to call it a dependency-only appeal. We get 10 to 12 of those a year or so, can vary, and certainly we could see more. The challenge with the dependency-only appeal is this. Having sat on that bench, and the folks who are paying attention, most of the folks in the room know this, we have to hold review hearings on a very regular basis by statute. If the child is under 18 months, we're holding them every 3 months. I sat on the strength court, which is the court to help victims of trafficking, juvenile victims of trafficking. We would hold those as much as once a month, or even more often, depending on what that person needed. Even for a child who is a teenager, they're every 6 months by statute. The challenge is getting those appeals processed before the next hearing. And the reason we're really focused on is a recent case out of our court. I know Judge Andrews, are you going to talk about that? GK case, or do you want me to? So the GK case that came out of our court, in which we ruled that when we use the standard traditional appeal model, by the time the case was ready for appeal, and our clerk was going to walk through what it takes to have that happen in the timeline, the issue was moved because another review hearing had occurred. The trial judge had issued a new finding of dependency based on the facts in existence at that time, and so it was moved. That hearing, that decision that had been appealed was moved. And anything our court would have done with it would have been of no consequence because there was a newer controlling dependency finding. It highlights an issue that I've been aware of all along. I will tell you, Chief Justice Brunel was keenly aware of it, which is how do we give parents and children a truly meaningful appeal in a dependency finding under those circumstances, because that's not unusual. So we have developed a process in our court to move those cases through in an accelerated fashion. And we're going to talk about it. The other part of that is the change to the special action rules that also refer to issues that involve the welfare of a child. And Judge Jacobs was sat on that commission, as did our chief clerk, Amy Wood. They can address that a little bit. That's why Judge Jacobs is here, is to talk about that. Because from our perspective, we need to address the dependency issues faster. And so what we did is a few weeks ago, we held a seminar on special actions. So anybody who is looking at that, I encourage you to watch it. We have it online. It would not have been something that a juvenile attorney might necessarily have looked at and thought, oh, that's important. But if you're looking at an issue for a dependency, either by way of appeal or a special action, it would behoove the attorneys to watch that. And it is CLE credit eligible, so that's always a good thing. So what I want to do is turn it over first to Amy Wood, because Amy is our chief clerk, and she can tell you all the steps we go through, and they're invisible to you for the most part, but what it takes to get a case ready for appeal and why we are not able to handle a dependency appeal in the regular process as quickly as we need to avoid the mootness issue. So Amy, you'd introduce yourself, and Amy has been with the court for 10 years at least. Eight, all right.
It feels like 10.
I tell you.
I've been around long.
Not for us, because Amy does amazing work, but for Amy and the work that we make her do, trust me, it has to feel more like 18. She is a very gifted administrator and does an incredible job. So Amy, if you would walk us through how the appeal comes in and why we run into this problem unless we do something different.
Sure thing. And I'm just going to kind of summarize the court rules that kind of lead to some of this in terms of timelines. So if we look at the Superior Court order as day 0, from that point in time, there's 15 days to get a notice of appeal filed. After the notice of appeal, of course, there's 20 days for the record to get compiled and sent to the Court of Appeals. Kind of running concurrently, there's 30 days for the transcripts to come to us. So by the time we have all of the record together, we're at 45 days. That's when briefing is starting. So now we've got 20 days for an opening brief, another 20 days for an answering brief. That's the point at which we try to assign a panel. Before a reply brief is even there, we try to do that on juvenile appeals. That was sort of done to try to shorten time frame. But that means we're not assigning a panel until we're at about 85 days if the case is smooth sailing, right? Because there could have been little bobbles in those time frames that I gave you. And so then the reply brief comes in 10 days later, so now we're at 95 days. And the panel needs some time to review and get together. So it may be, 125 days before folks are starting to work on the decision and getting that out the door. So we're already well into the chunk of time that the Superior Court would be making that next decision. And you can see how fairly predictably we would be in this situation on dependencies often.
And I will tell you, the glitches that Amy mentioned are common. Just getting the transcript, and it's fairly routine for a court reporter to say, I need an extra 30 days, and as a standard practice, we will grant that. One delay in getting the transcript could push us past the 6-month line. And that's almost a commonplace occurrence. The panel has to meet. When we assign it to a panel, it's not like they hear it the next day. They have 45 or sometimes 60 days to look at it before they even conference the case. And then rarely does a decision issue the day after conference. So when you really add it all up, we're just not set up to get those done. I will tell you that after GK came out, we have had 2 cases where I've authorized the decision to be filed off cycle, because we file our decisions on Tuesdays and Thursdays, so that we could get it out before the hearing date the next day. But we're just bumping up against it that tightly. And some of them we can't. And so from our perspective, we're not giving people that full and fair opportunity to be heard, not on purpose, not by design, but simply because our system didn't get set up to do it. So that's why we're adopting a new process. What I want to do is just walk through that process a little bit with you. Judge Howe, is there anything you want to add on it at this point?
No,
I don't want to.
No, I think you're good.
So what we did is we sat down. I will tell you a panel of people. I sat on the juvenile court, another judge who sat on the juvenile court. Our staff attorneys, our chief staff attorney, Patrick Lefroy, who is our juvenile court staff attorney, who has 14 years experience representing parents and families in these matters. Our chief clerk, Judge Howe, Judge Jacobs, because of his special action experience, to look at how we could do this. And what we came up with is a process in which, if a dependency-only appeal comes in, so again, start with that. Our clerks are paying attention. They always do. We know what appeals come in. So if they get a dependency only notice of appeal, it immediately goes to our staff attorney who will review it. We'll look for any jurisdictional issues in order, and I will tell you, you have the rule will require that the notice of appeal tell us what the next hearing date is and attach a copy of the order that's being appealed so that we have that information. And we will be looking to make recommendations. Once we've done that initial review and have a handle on what needs to happen and what we think will make the most sense, it will then be assigned to the HOT panel. For those who don't know, the HOT panel is the panel in our court that's responsible for receiving special actions that week. The HOT panel works on a weekly basis. It changes every week. But it will be assigned as if it is a special action so that it gets in front of a panel within 2 or 3 days, hopefully within the day, but certainly within 2 or 3 days if it comes in late on a Friday. So that panel can look at it. The decision tree for that panel is threefold. Does the panel say, okay, this came in, it's been filed as an appeal. We will, though, treat it as a special action so it moves quickly. Or the panel could say, we're not going to treat it as special action, but we are going to accelerate the briefing schedule in order the briefing to move quickly, and we take out the delay so that brief gets done as quickly as possible and gets in front of the panel. The third option on the decision tree is the panel could decide that they're just going to let it go forward as a regular appeal. And that is something the panel always has the discretion to decide, but we felt it was important that, that's the decision tree before the panel and that they will be making. If it is treated as a special action, some questions may come up about fees and how transcripts are paid for. It will be treated as an appeal, so that the transcripts will still be paid as if it was an appeal, even if the panel converts it to a special action. A second question would be, if they convert it to a special action, does that mean they're just going to deny jurisdiction and move away? And the answer is no. They should not accept and treat it as a special action with the goal of declining jurisdiction. If they treat it as a special action, that same order should include an acceptance of special action jurisdiction, so the case gets heard. The panel then can set the process moving very quickly, and hopefully within 60 to 75 days, we've gotten a decision out. Now, it could be that you get a decision that says written decision to follow, but an affirm or a reverse. Our goal will be to get a memorandum decision out within that time, but if it's not possible, if nothing else before that next hearing, our goal is to have a ruling out so that you folks know, am I going forward or did it get reversed and do we need to retool below? So that is what we're trying to do. And the goal is to, again, move these quickly for folks. If we order oral argument or folks feel it's necessary, we certainly will accommodate that. That can slow down just a little, but we can still work with it within the hearing timeframes. We are also teeing up our court so that, especially if you're not in Maricopa County, and this is an important thing, we can do the oral argument remotely or in a hybrid fashion. Our court, by the end of the year, will have that full capability to do that so that, for example, the AG's coming across the street, not quite, but close. Mm-hmm. But the person from Apache or Navajo or Mojave County is doing a full day drive. And so we want to make sure that if we're going to have an oral argument, we give folks that opportunity. So folks out there know that we will entertain those and take those quite seriously. Yes, Judge Foster.
If I could just ask a question.
Sure.
Because this HOT panel that goes through this 3-branch process, they can still, however, find that there's no jurisdiction for matters being presented, or no?
Well, I'll start with there is a right to appeal a dependency finding. Mm-hmm. So that's in statute. Where we run into a jurisdictional problem is sometimes the order is incomplete. I'll use paternity as an example. There hasn't been a finding of paternity. One of the factors that the panel may use to decide to do special action instead of an accelerated appeal, if that doesn't affect a special action, because we're accepting jurisdiction on different grounds and it's not based on the statute. So, for example, if it had a jurisdictional defect like that, the panel could move forward with it as a special action. What we do in that review is identify the jurisdictional issues, and the panel likely would issue an order that treats it as an appeal to say, look, there's a jurisdictional problem. we revest jurisdiction in the Superior Court for the limited purpose of clearing up this jurisdictional issue. So again, they come up, and I'll tell you that's one of the things that can really slow us down is we'll have that, and we traditionally will try and let people get their appeal to move forward, so we'll revest to allow it to get fixed. That can take a couple of months. Our goal with this, with the dependency on the appeal, is to say, I'm giving you 15 days to fix this kind of thing, for just that reason. So yes, we may deal with jurisdictional issues, but ideally a dependency won't be dismissed or denied, the appeal denied and affirmed just because of a jurisdictional issue, if that makes sense. All right, so I think that covered the piece that I wanted to cover. And again, we're not giving you all the details. There'll be an administrative order. We'll have forms of order. But we wanted you folks to be aware that this is a process. We didn't want you to be just surprised to see it as we move forward, because we do want to see these cases resolved quickly. And I think if I was the lawyer sitting out there, I go, why did my case get accelerated? What happened? If you know it's part of the process, you're not surprised and you're prepared for it as far as you're playing. Yes.
Shameless plug. If you aren't already subscribed to our news list, you would receive notification whenever an administrative order goes out if you're on it. And you can find that on our website. So just FYI.
And our clerks, and I will tell you, Amy is a humble person, but her clerks are amazing. And they work very hard, and we work with them through the process so that if they had a question, we could answer it now. So it wasn't a question that comes up when it comes in the door. Can I promise you there's something we didn't expect? I 100% will promise you that. We're doing our best to not have it, and when it does happen, we'll get on it right away. But I think we're set to have this go very smoothly, and you can reach out to the clerk's office with questions. They can't give you legal advice, but they can at least answer the questions and about the process and everything. With that, what I want to do is turn it over to Judge Jacobs, because he was involved in developing the new special action rules, the comprehensive change. And one of the things that was adopted is that provision. So Judge Jacobs, if you could talk about how that process works now and how you see it working with this new program.
Yeah. Thanks a lot, Judge Goss. So on the special action piece of this, there's sort of two different approaches to it. So in overview, there is a conventional special action that always remains available to you as a procedural device. And then there is the filing of an appeal, which, as Judge Goss just explained, can put you into a decision tree where three different things can happen, including your conventional appeal might be deemed a special action. So, but to step back, as Judge Goss asked, and just for a moment talk about the process by how we got here, the special action rules were kind of a poor and antiquated set of rules. They had not been modified in 55 years, and the biggest problem with them was that they didn't state the criteria pursuant to which the courts in this building would exercise their discretionary jurisdiction over something that should be dealt with faster. And so the Supreme Court set up a commission in 2023, and that commission really fairly effectively resolved that issue by incorporating many different parts of existing case law. And some of those parts speak directly to the issues that are in front of you today. So there will be a rule effective January 1, 2025, that sets out and it's the title, Factors for Accepting or Declining Jurisdiction of Appellate Special Actions. And some of this was in case law, but the case law was not always well known and was not always widely available. So two of the subparts of that really bear heavily on the work that you do. So factors for accepting, there's a subpart B, factors that support accepting, and C, factors that support declining jurisdiction. C is not relevant here, but B is. Within the factors that support accepting jurisdiction, some of them are the things you'd expect: first impression, statewide importance, it's about a privilege. But here we go with juvenile people. B5, tending to evade review, including questions that may become moot before an appeal. So this is basically how Judge Goss already explained the GK case. You have a situation where, at least commonly, based on our common course of performance, as our clerk just explained it to you, that question would tend to evade review, and it would tend to become moot, which was the whole reason there's a convening about this particular sub-issue. And second, even more squarely on point, the next factor, B6, involving the welfare of children, okay, where the harm complained of can only be prevented by resolution before an appeal. And that's sort of definitionally what you're talking about. So these rules are available. it does not foreclose you from making the choice to exercise the route of a conventional appeal, which remains open to you and is important. But you also have, going back to how I started, you have the option, invoking these factors, to file this conventional special action and not wait to file it as a as a conventional appeal. And if you do so, you might shave some modest amount of further time off the schedule, if that is in fact a concern. But even if you don't, when the hot panel is deciding whether to treat something as a special action, your notice of appeal and the grounds probably are going to speak to these very subject matters. The question of whether this dependency appeal tends to evade review and may become moot before appeal, or of course involves the welfare of children, we all know that, but where the harm complained of can only be prevented by resolution before an appeal. So again, just from a new special action rule standpoint, the takeaway is this was already the law, but now it's really pulled up and made, fresh on the face of the rule. So we would urge you just to be mindful of your different remedies and the fact that you can exercise the choice either to initiate a special action right off as fast as you can, probably save 10, 15, 20 days in the timeline that Amy described. And second of all, that those criteria would apply when our hot panel sits and performs the function Judge Goss explained of deciding which of the three tracks your conventional appeal should be slotted into.
And one thing I'd suggest is if you do have a preference, probably express it in your, whatever notice you might file to say, would prefer it to go through the traditional appeal, would prefer it to go through that. It doesn't hurt to let the court know what you're thinking. But that is what we're trying to do because we recognize that it's been historic as an issue. We've often not been able to get these done in a timely manner. GTA just really highlights the fact that it really is a moot issue. Now, that is up for review. They could change it, but from my perspective, that doesn't change our concern, which is getting them done timely for these families, so that if for some reason, whatever reason the court decides that it should be reversed, that happens quickly for those folks and we can get folks back on track. So that's why we did this. This seemed like a good forum. It's not on track. One of the things that you will have to make a decision on is, what if we don't have that affidavit, and would you ask to waive it because the affidavit could slow us down at that point? And there's nothing I can do about it, though my goal is with this convening to see that affidavit requirement go away as quickly as possible because we have the disclosure back on track and we don't have to be doing that. Judge Jacobs.
I apologize for interjecting, but something occurred to me in my notes that Judge Goss had raised. There was discussion about the potential for accepting jurisdiction, and another change, which I just realized as we're speaking, cuts across this, is that if our court decides to accept special action jurisdiction, we're now required to issue reasoned decisions. So you don't have to worry about the acceptance of jurisdiction and just the denial of relief without explanation. So if jurisdiction is accepted, there will be some form of reasoned decision, and that's important to keep in mind as you weigh your choices.
Thank you. It was a very good point, and I completely forgot about that. So yeah, you're going to get a decision either way. And I think that's important for everybody to know why the court's making a decision. It's guidance down below and what you need to do and how you need to handle it. So I'm hopefully that this was a useful intro to get folks started and thinking about this. And it's not out of the question, of course, that the AG would appeal a denial and want to see that move quickly too. So I think this affects both sides, and certainly both sides will be involved in those appeals. And we see them regularly, though they're not the most common form of juvenile appeal. We felt that it was important that we not disregard them any longer and make sure that we got on top of them. Not that we were disregarding them, but we just didn't move quite as quickly as we could have. Any questions, any comments from anybody? All right. So I'm going to excuse the other folks who are here at the table. Judge Howell, did you want to say anything before you leave?
No, I think you guys totally did well.
All right, thank you. So what I want to do today is get an update on where we stand with the disclosure. I know Judge Boostum, actually I'm going to let Judge Howell get himself together.
All right. Yeah, I'm good.
Sounds caught up. There you go. All right. I know there was the hearing with Judge Bustamante earlier today. I got a report on that, so I have an understanding that we have something like 6 or so cases that we expect to be moving through the affidavit. process here fairly quickly. We have one case that we have gotten the affidavit that we're able to move forward on the appeal. That still leaves a lot of appeals that we need to move forward. And I know Judge Bustamante is pushing to have that happen. I know folks in the outer counties are also working on that. So I'm in particular curious to see where folks are at in Maricopa County, but also how we're doing then with the other counties, because we do have a handful, not a lot, but a handful, and I want to make sure that they're getting resolved as quickly as possible. And with that, what I want to do is start with Ms. Patak on your status. Then I'm going to, so folks know, go to Ms. Wright to talk about where the AG is at and where that process is going. Then I want to hear from Judge Foster, if you would. And I know you're not a judge anymore, but once a judge, always a judge, I think is to say. All right, so they always say once a senator, always a senator, but that's my legislative background. And I'm sorry, if you would, could you just state your name so everyone knows who's here?
I'm Shannon Burns. I'm with the Office of Public Advocate.
All right, and I want to give you a chance also, if you want to weigh in. One of the things that I do want to do is continue to talk about the data points and the documents list. And I know when we left last time, folks were really working and getting the meeting set up. My understanding is a lot of meetings have happened, a lot of review has happened. So we're making progress now. That's not the end of it. Then we have to do the next step. How do we get this online? How do we get it happening? How does Mr. Hinsey fix the world for us? Because it's the magic of computers that will make this work. And also just where things are at with the redaction process, because that was one of the discussions. What happens if things get backed up? Are we teed up to make sure it doesn't slow it down? But that's something, Ms. Patak, if you want to cover that up front, you're welcome to. I just put it at the end so that we didn't overlook it.
Okay.
And if you would, you see me leaning in. Folks around the room, and I know there aren't as many folks here today, but it's really difficult here in the room if you don't lean into the mic.
Okay. To give you an update, and I did touch base with CRCU after that hearing because I think there was a little bit of confusion because they're in different spots. And so the team at DCS in Maricopa County has reviewed 30 cases, and they know which documents in those 30 cases have not been disclosed. Once we have the documents identified, we have to download them. We then send them to the AG's office who's been doing the review. They need a little bit of help. They don't have the capacity to do all the redactions themselves. So we have two potential solutions. One, we did reach out to a different division in the office who's going to loan us a couple paralegals. So we'll pay them overtime while they do some of the redaction. So that will help. The other piece to that is that, so Judge Bustamante obviously wants this done quicker. So we will.
From my understanding, is it December 3rd?
She gave it December. She wanted us done December 2nd, and there's a hearing on December 3rd. I didn't look at the calendar because next week is a holiday. So, but we think, I asked my staff, they think 3 staff could do, if that was their whole duty. We've been doing it right now in just overtime. If we pulled 3 people off their current duties, we could get through it in a week. That is the review. So after the review, we have to pull the documents, we have to do the redactions. And then the other piece is the emails. So IT has been pulling the emails. I have been reviewing them. I have been redacting them. And, you know, the polls are always like overbroad. There's stuff about like a potluck, or you know what I mean? And so you're taking some of those out too. So, so that is the plan. We have, I think you said 5 or 6 cases next week that we'll be ready to go on in a status conference. We are keeping an eye on CRCU's volume. It is going up, and I think it's because in the cases, so what the AG has started to have the conversation in the trial court level. Before we go to trial, you need to avow that you have done everything. So that way, when it gets to you, we're not doing this whole thing.
Exactly.
So we're handling it on the front end, but I think staff is freaking out a little bit and saying like, well, I can't be sure, so I'm just going to redo everything. And then CRCU is getting these like 10, 20, 30,000 page documents that they're like trials in a week. And, you know, and so then that's backing them up. So our plan is we're going to have these people assigned totally to the Court of Appeals project. And then we're going to send their work to the contractor and just whatever, you know, these big ones that are coming in to send those out to, because we don't want to accrue that backlog. We have met with another vendor. I think I said this maybe before. The vendor we're using now, they're attorneys, so they're really good and they don't need training, but they're also very expensive. And so there are redaction firms in Arizona that can do it for a lot cheaper, but they require more ramp up time. So that's something we'll have to do like when we're not in the crisis and have them kind of on the back burner. So we're going to continue to use this firm for now while working with some of the cheaper firms, and hopefully the expensive firm isn't launching, and that's my plan. But so that's kind of where we're at as far as that goes.
And as you're going through this, the one question always comes to mind, there are other cases that are moving through the pipeline, and you did refer to them, but they're moving along. So I know we're doing catch up on the appeal cases, but on the cases that are going to trial, we're making sure we're staying on top of that, and we're getting, including the additional systemic issues, the emails, the things like that in that.
So we've addressed that kind of two ways. One, we did put out the administrative order letting staff know you are expected to case note your emails, the ones that aren't like among all the parties. So you're expected to case note those. We prefer that you don't text. If you do text, you're expected to case note the text as well. And we did meet with a vendor on the texting. We can give an update on that too about a solution. I'm going to have to, because I will not be able to explain it in just a minute. And then I think so that was one. And then the other piece is the conversation that AGs are having, which I have told them, and I think we all agree, we're talking holistically. We're talking like, I didn't know I was supposed to disclose case notes. We're not talking about like this, I missed one single visitation. Like those kind of conversations.
And I think the systemic issue, it's not oops, I made one mistake.
Yeah.
We're human.
Yeah. Yeah.
Unless, of course, it's a lot, it happens in every case and it's the one document. We might be having a different discussion, but that's at the trial court level.
Right. So I think my impression of this, and I could be wrong, my impression of this is we're going through kind of like a growing phase right now. We're trying to work it out. In a couple months from now, once the process they're used to it, it's not going to be quite as burdensome. And also on these reviews, I will say they took at the beginning longer because people were figuring them out, and now I feel like they're moving very quickly. Like we had someone from policy come over and help CRCU because they had some free time, and she's getting them done like one a day. So I think it's getting better. I'll say that.
I think the more you do it, the easier it gets. So, Mr. Hinsey, if you want to fill us in on the texting, because I know texting is important. It is really an efficient way to keep contact, but the problem is you also have to make a record of it. So what do we got?
Let me go through just a couple of the updates on case notes and things first, and then I'll hit the texting. So on the ability to disclose notes, we've made some progress there, but I just want to give some folks a sense of the volume we're talking about. So on Friday, we started copying the data into a place that we're going to be able to use for disclosure. It took about 4 days for all the data to move over. It's roughly 100 million records that are in the system there. There are 1.3 billion data points that are in that set of data that's moving over. And just for some context on recency, if we're looking at just notes that were created today before 1 o'clock, there's 105,000 data points related to these notes that are going for. So it is a lot of information that we'll be sharing. So the plus side, though, is that part seems to be working on our testing, that we're able to replicate the stuff down, and we're continuing to march towards that goal January 1 of being able to disclose all that trackable and packet. To that point, we have started some internal and external communication with some folks that are from the AG's office. We're working with Paul, thank you for giving us his name, to try to get some other folks to test this around Christmas time so that we can be ready for that go live in January 1. I'm expecting that there are going to be a lot of overwhelmed lawyers come January 1, just with that amount of data that's going to come through. So just something that I'm trying to prepare folks for and make sure we've got a good plan of communicating that it's going to be a lot. That doesn't solve the redaction piece yet, so that still is going to be done manually after the disclosure packets are made. So that's the DCS notes part. I'm optimistic about us moving forward with that as a final.
And I know you've talked in terms of data points, but in terms of how many case notes, what number of case notes are we actually talking about? Yeah, I think that's what most people
Right.
are going to think of this as.
Sure. So there are 30 million notes that are moving over. Again, this goes back to the 90s. So it's a lot. And the other piece that I would couple with it is that the notes by themselves are one. The number of people that impacts is 70 million people. So you'll have a record of 70 million individuals and the notes they associate with. Hopefully that makes sense.
And for example, today, how many case notes on average on a day?
Today there are 63,000 notes that have been entered in the system so far today, as of one, and 42,000 people that were involved in those notes.
As in litigants and children and folks affected by it?
So I will clarify that includes investigations as well. So it's not all just going to be children that are at dependency matters. So it's going to be less than that are subject to what we're talking about here.
But at the same time, if the investigation turns into something, then it becomes a case note that you folks are certainly going to want and want that for the dependency hearing. And so I understand that. So,
correct.
And so we are on track. We're still moving forward. I will say, as someone who's had to work with staff through this kind of testing process, I appreciate that it's a lot of work, and it's going to grind folks down. And it's going to grind folks down on both sides as you get all of this information that you're not used to getting. So we need to be prepared for that and make sure that we recognize it, because it is not easy, and doing that testing can be really grueling. It's rather boring and repetitive, but it has to be done over and over again to make sure it really works. So thank you for doing that. Thanks for folks getting that organized. And it sounds like your folks are kind of helping to make sure that that happens as well. And so I appreciate that. Did you have any questions for them on this part of it?
No.
Okay. Ms. Wright, I think you're up.
So we have had 2 meetings with Defense Counsel and Children's Counsel from both Maricopa County agencies. We also had the Office of Public Defense Services for Maricopa County and Pima County. So we tried to include some people from around the state to go through we end up with 425 data points. Thankfully, Stephen was available for both of those meetings. He came, he brought his computer, he pulled documents up on the big screen so we could all look at them and see exactly what these documents contained in these data points are. Having gone through those, we narrowed it down, I think, to about 275-ish, which I think also gave the department an idea of areas where, some of these data points had 3 documents in them from the beginning of time, essentially. So it's not a data point that's being collected anymore or whatever was really used. So I think it also provided the department with the information it needed to sort of tighten the system up and maybe remove some of those non-essential areas. I felt like it was a pretty fruitful conversation. It was very interesting to listen to Children's Counsel and what Children's Counsel think is important versus Parents Counsel, and sometimes those were not. This is not the same information. Judge Foster would say, "I don't think I need that," and Bill Owsley said, "I absolutely need that." So it was an interesting conversation. But I think the important piece of it is the transparency that the department's willing to show. That this is everything that we have, and we want you all to know what everything looks like so that you can see what we are and are not providing to you. And so I think hopefully that was enlightening to the parties to be able to see that and see that DCS is at this point, we want to make sure everyone understands that there is transparency there. So we're basically waiting till the January 1st date when it will be easier for the case managers to get all of this information out. We are working from our end to make sure that we are assisting the case managers. As Ms. Patak said, I think some of them are freaking out. They're signing a legal document stating that they've disclosed everything, and they're taking it very seriously. And so some of the trial dates have been pushed out because we want to make sure that the case manager feels safe and secure in signing that document, that they have provided everything to the court. We're hoping that that's an upstream sort of change so that when we come downstream, if anything is appealed, the affidavit's already been submitted prior to the trial, and we're not going to have to go through this review process. As far as the review process is concerned, we have a team of 3 people who are receiving the documents from the department. Pretty much Ms. Kelmar, sitting next to me, is going through all of them herself with her 2 paralegals to evaluate. The department is sending a set of documents that they say we did not disclose these documents. The AG's office, however, might have subpoenaed those documents for a trial setting. So, she's looking at documents side by side, and there may be 200, 300-page documents to ensure that what the department thinks didn't get disclosed was disclosed by our office. And sometimes the difference could be when we issued our subpoena, it was for a couple of weeks before trial. So the AG's documentation ends on January 3rd, but then there may have been other supplemental information that comes in after. But, we have to look to see which parts of it were and were not disclosed. So it is extremely time consuming. So I think due to Judge Bustamante recent order, we are going to have to try to find some additional staff to go through that, because we just won't be able to make it by December 2nd if we don't do that. And unfortunately, litigation continues, and our entire section probably has 150 people in it who are constantly in trial and working through their cases. So that's been our issue. We don't have the additional funding to be able to go and outsource that. Our funding is provided through, a line item that the legislature assigns to us, and we don't have any other place to go get that. We can't ask the Attorney General's office for money because of the separation of the budgets. So we are trying to do the best that we can with regard to that. So at a certain point in time, I'm concerned that it might be our office that's holding things up simply due to a manpower issue.
And in that regard, is there any way that the department can help with that? In other words, to, again, do some outsourcing for some of that to make sure that it stays on track? Because I don't want that to be a holdup that you say in 6 months, we're still trying because we're backed up.
So DCS has been, they are looking at all avenues. They actually reached out to one of our other divisions in the Attorney General's office to see if there were available paralegals, and I think 2 or 3 have agreed to assist, and the department is paying for their overtime. So DCS they are willing to provide the resources. Our problem is bodies.
Sure.
We just don't have the bodies.
Well, sorry, if I can add to that too. The training piece. So we could get bodies. I could hire 100 interns tomorrow to do it, but by the time we train them, and you want a quality job done, that takes longer than just doing it, internally. And the division that we use within the AG's office represents us in other matters, so they're used to our documents, and they don't need training, they can do it right away. So I think that's
absolutely.
How long do we think it's going to take? Because you said, are you going to just make clear? Are you going to meet Judge Bustamante's December 3rd order? Is that not going to?
So that order came down
just
an hour ago.
I know.
And so we have not had the opportunity we will absolutely do everything in our power to meet that deadline. We would like for this to be done as well behind us, so that we can move forward and make sure that the trial courts are back on track and that we aren't holding anyone up. I think things are moving more quickly in the smaller counties. So those we have the unit chief of the Apache, Navajo, Yavapai, Coconino counties. She's doing a review with the department. They're working very, very closely together. So those outerline county appeals will be moving through much more quickly than Maricopa County, just because of volume.
Go ahead.
Here, Andrea Culver with the AG's office. So I didn't give an update, and part of the reason that you haven't seen those outlying counties is because in those counties the judges are setting status conferences after we've filed the documents. So for a number of them, for example, La Paz County, they're finished, but the hearings are set in December. So we have in La Paz County, we've received and filed all the documents. We are almost done with Yavapai County. We just have one set of documents left there. We're about halfway through Mojave County. And then in Yuma, we've had a few status conferences, but we're still waiting for the documents. So that's why there's a delay, because we're waiting for the status conferences to occur. And they're actually reappointing counsel in those outlying counties as well.
And Mojave is reappointed at this point?
Yeah, they're reappointing counsel and having hearings. That's why it's taking a little bit longer. And then in Maricopa County, the process is different.
Sure. No, and we expect it to be different. The important thing is I'm not going to try and micromanage Superior Court judges on that. Going back, because we didn't really hit on the text messages, and so, Mr. Hinsey, do you want to? It occurred to me we didn't revisit.
Yes. So a couple things. So the emails and text messages, I want to hit on both of those. So I know emails right now, we have folks that are copying and pasting that information in the case notes. Post January 1, we're looking at adding in automation to link up emails to Guardian so that it should allow for people to ingest that information with no extra copy pasting. So should be more information being pulled in, but that'll also give us some burn-in time on this first appointment so people can see what the notes look like and we can adjust from it. Importantly, that also doesn't require us to spend a bunch of extra money. So it's an easier thing for us to pull in at the moment, it seems. The texting is a different story. So there is some software that we're exploring that will be able to provide a phone number that we can port over everybody's current phone numbers into, and has the ability to talk with our software and integrate that. Very early stages there. We need to go through all of the Homeland Security checks and integrations. There are some obvious questions that I have about it of what if people call from a blocked number, or if they get a burner phone and you change the phones, like how do we handle those scenarios? So there's a lot of just logistical things that we need to think through, but we are exploring that. It's promising technology at the moment. So we should know sometime probably early spring on whether or not that's a viable solution for us.
In the meantime, absent exceptional circumstances, we're just not using the text messages.
Yes.
And if they do use them, they have to load them in as a case note so that at least there's a record of those
Yes.
and would be disclosed that way.
Yes.
And I do appreciate that this is not easy, and I know that changing the system that wasn't designed to do this, but I appreciate that you folks are making that happen. And it needs to. So I'm not suggesting it's not a necessary thing. Wish this had been put in place 3 years ago, and none of us would be sitting here, and we folks could plan for their holiday week next week. Over here, did you folks have any questions for any of the folks at this point before I turn it over to you to get an update from your perspective on where things stand? I know it's not happening fast enough, but I do have this challenge of physical human limitation. I can't magically make it happen. I got to keep the train moving to make sure it goes.
I don't have any questions, but I'll have some comments.
Then why don't you go ahead with your comments?
Okay. I'm constantly shifting between grand cases and ongoing cases.
Yeah.
Okay. And let me just address the remand cases first, because it's proving to be creating some, and I'm not sure about Shannon's office, but my office, a little bit of confusion about where things are. These cases have come back. Judge Bustamante has her status conferences. And maybe some of these things should be resolved at the trial level. But we have situations where some cases have been remanded where no new documents have been disclosed. Some have documents that have been disclosed. And from our point of view, and this was a matter of some consternation months back when the school authority thing came up, what to do with all these documents, is that even in cases where we have been the appellant, sometimes our clients are far into the wind. We don't know where they are. So even if we have documents, and we raise this in one of our motions at the trial level, before we can take a position, because the AG's office, DCS, has to take a position, whether or not these documents are going to affect the outcome. Can't do that without talking to the client. Sometimes some of those documents may say something that triggers something in them that causes them to trigger something else. I don't know. And so we still have those challenges on our side. I'm just talking about the efficiency. I'm not blaming them for anything, just trying to illuminate some things that people may not be aware of. In our meeting today, I think we talked about 15 or 20 cases that were either ready to come back to you or not ready to come back to you, or kind of ready to come back to you. And we had 50 cases on the docket for today. So we had a number of cases that are not resolved, and at least the ones I appeared on, they were in various states of disclosure or non-disclosure, or we had one case where, I guess the documents had come in. There was a motion to reappoint our attorney. The motion was denied. The judge was demanded ruled on the documents, which I thought was curious route for that to take. And so I don't know what's going to happen with that case because once again, the claims. So the matter of the lateness of the disclosure in these cases create all types of problems I don't necessarily foresee. How they get fixed, I don't know. All I know is, at least for our office, there's nothing we can really do in a case that's coming back from remand where we had been withdrawn below, but haven't been, like I said, that's in various different modes. I guess my only question for Andre is, what can we expect as far as that's concerned? Because I've got some cases where we've been reappointed, some cases where we have not been reappointed. As I said to her and said to you when we were here before, we won't object to reappointment in any cases where we're the appellant. Okay, because the way our office operates, in some cases, the way the court operates, we get a decision on determination. The order comes out withdrawing counsel. Okay, goes up to you, comes back on remand, and now my lawyers tell me I don't have any documents, I don't have any order reappointing. What do? I can't do anything to your reappointment. So those are some of the things that need to get some resolution. Okay. And then we're willing to do that. You know, on cases where we didn't appeal, I don't think we have a stake in that. I don't think there's anything to say when we appeal. We're pretty much close with it. As far as remand's concerned, at least that's where my office for those kinds of problems. Shannon's office is a little bit different because they do their own things, not withdrawn.
When an appeal gets filed, though, somebody is appointed to represent the parent. Who handles that appeal for you folks if you're not handling it?
You know, that even happens in interesting ways. And I saw one today where it's a termination. The minute entry said, upon the close of the appeal, all counsel will be relieved. So the notice of appeal went in, and there was an order appointing counsel. What my office usually does is we file a notice of appeal, then we file another document, a motion to appoint appellate counsel. And it happened in this case. It kind of happened automatically. I called the attorney and I said, how did that happen? He said, what do you mean? I said, well, the court just, did they automatically appoint somebody not of our office? He says, I guess so. Okay. So there's a bit of confusion as to how that happens. But our particular practice is to file that second motion so we know we're out of the case, number one, because we don't do appeals. Number two, that the client does have an appellate attorney. That's our standard practice. But once again, if there's a remand getting back, then we need the point.
And as I understand it, at least in most of the other counties, I know you're not in them, that's happening. Are you not getting reappointed in a lot of cases in Maricopa County, or what's happening with that appointment? You identified one that Judge Bustamante resolved today, and I'm not trying to get involved in that at all, but are folks getting reappointed, not for purposes of service, but for other purposes?
People are getting reappointed, and like I'm saying, I'm not exactly sure what the criteria is, whether they get reappointed in each and every case, or you're doing it on a case-by-case basis, and that's the only confusion I have. And I'm only talking about my office. The rest of Maricopa County, you got to remember, we've got my office, Shannon's office, Bill's office, but then we've got a whole bevy of private counsel and contracts. I don't know what's happening.
So, and I guess if counsel has been appointed on appeal, if your folks get reappointed, do they reach out to the folks who have been appointed on the appeal portion of it? I'm not trying to get into attorney-client privilege, but it seems to me that's a natural connection to say, okay, let me reach you're handling the appeal, and I'm back on here because of the review.
Well, we have to contact them because now we've got these disclosures and they don't.
Yeah. Okay. So it's a kind of a windy process, and the goal here is to have that going forward not be a windy process because it happens up front.
Right.
One of the reasons we were doing this is to make sure that that happened. How is your office finding the current disclosure? I heard some cases have been continued for a little while because some disclosure, but are you generally seeing the disclosure happening kindly now?
There's a great avalanche of documents coming into my office.
There's what?
A great avalanche of documents coming into my office.
Sometimes, I'm not suggesting you don't want it and don't need it, but sometimes you got to be careful what you ask for, right?
No.
It's
That's an attorney.
miracle on 34th Street. Here's the mail for Santa.
There you go.
But things seem to be moving, and the case notes and things like that are starting to come in.
I did not mean to interrupt. I thought you might finish, Mr. Hoffer. But
Yeah, well, on that point, yeah. On the romance.
Yeah. Okay.
That's my only comment about those things. So we just need some clarification, just to make sure we're doing what we need to do on our side to get things moving. Back to you.
And anything else you wanted to comment on?
On what we've done since we were here last. We met twice, as Ms. Ryan has indicated, and I must say, by the time we got done, there was a whole lot of concessions on the part of DCS that said, "Oh, we'll disclose that, we'll disclose that, we'll disclose that, we'll do it time," and so we appreciate that, and I think that was a very productive thing on their part. That list of documents that we had, and Steve has indicated, when they're talking about moving documents, they're moving documents over a huge period of time. And we had a number of classification of documents there that went back to CPS that we figured need to be disclosed because they're nothing, they're not separate at this point.
Yeah.
So that exercise was good, and I think I had said to Kristen, or I sent to somebody, a list of what our office felt was appropriate, which was a lot shorter than 419 categories of documents. So when we were here last night, I said to you and everybody else, I think we can be very productive if we keep meeting in this fashion, just to get done so that we have the ability to see the documents and understand and talk across the table and figure out what we know and figure out what we don't know. The other issue of our concern is that there's 419 documents are on this list in the on-base system can be reduced to PDF form. Yeah. If I have to have a trial in person, I can create a document and say, "Judge, I'd like to offer exhibit number 22. I'll have it marked evidence. This Guardian system has a number of documents, or information, I should say, in it that is just as relevant that needs to be disclosed. We only know a tip of the iceberg of what that is. And I asked whether there was a list of the kinds of things that go into Guardian so that we know what's there, because as we said when we came a long time ago, we can't say that this is going to be the list of things that must be disclosed because we don't know what we don't know. Okay. That case notes are generated into the computer, that other things are generated, what they are, and Steve indicated that it's a huge list of things. But we still need to have some understanding about the kind of things that we think that we need that might be in that system. So that's on our to-do list to address and get to.
And that's the data points that aren't part of a document. And some of them may be. That's the thing. And so figuring out what, and I just to say it again, sorry for not getting the microphone for folks, but the data points that are out there, some of them may actually be a part of the documents you're getting. You don't know, but until the next meeting or several meetings, maybe what are the data points then that also need to be a part of this is what you seem to be indicating.
Exactly.
All right.
Yeah, and there was a person, I guess, who was on the feed from the original session now, Paul Loveless, and he reached out to me this morning, not so long before he had to come down here, about putting together a work group, and that's fine and dandy, and I said to him, and that's great, that our focus right now is a little bit more hands-on, because we have to be. We need to be able to get case notes, we need to be able to get emails, and text messages, those sorts of things. We talked about where emails go. Well, oftentimes emails are between the case manager and our client. And they're saying, why do we have to disclose to you what your client already has? I said, that's a valid point. More valid is this: emails between the case manager and service provider, or the SBO, or whoever, because that can contain information, once again, that can lead to political evidence at trial. And that's what our concerns are. It's not just what our client gets. And but you sat on that bench, and I think that you probably came to understand that oftentimes clients aren't real cooperative about getting their attorneys.
I was just at an event where the discussion was people show up and say, hi, I'm a lawyer. I'm here to work with you. There's no expense to you. I'm going to do these things. And people still say no because of a lack of trust. And I get that.
Yeah.
And I think that I understand the challenge.
That's our cultural challenge on our side.
Sure. No, I
think
think
cultural challenge.
it is. And I think it's important, that those emails do contain a lot of information. Emails to and from foster parents may provide a lot of information, but their redactions necessary, but there's information in those. So there's a lot that I understand you folks need to truly be able to advise your clients and assess what's going on. Yeah. My goal is to, again, I can't right the ship in 20 seconds. The Poseidon never did turn the right side, as I recall, after that wave went through, for those who are old enough to remember the Poseidon adventure. But we can get the ship righted, and we just need to stick with it. So I think...
Well, they don't build ships that turn over like that.
What's that?
You can build ships that don't turn over like that.
I understand. The one thing, and I always come back to this, is, and you acknowledged it, and I appreciate it, that you have a department that's being transparent and is willing to uncork the bottle, and the genie's out, as they say, and now how do we move forward so that everybody gets what they need? But I don't think you can go back to putting the cork back in the genie. So I think we've got a department that's going to be doing more and is concerned about this. And I don't say that they weren't before, perhaps just didn't recognize the importance of it or focus on it, but they are now. So, and I appreciate that that's happening. Is there anything that you wanted to add? And then, because I'll give you a chance to respond.
Well, I was just going to add in regards to procedural. So our office is a little bit different in that we have an appellate attorney in our office. We still do like to have a motion to have the trial attorney be appointed just because it makes it easier, but things aren't slipping through the cracks. And I'm not saying things are with them, but I think that there's more chances of it happening with them just because they're not in the same office. The only time we don't is when there's a conflict for us to stay on the appeal. So the biggest concern that I have, the biggest concern I have overall is just the amount of documents that are coming in, because in addition to the caseload that attorneys have, they have all of that coming in. So I think my question would just be, as far as January 1st goes, I guess what I'm trying to think about is preparing the support staff, preparing the attorneys. Like, what should be our expectation moving forward? I mean, normally, I assume it's going to still go through JAX, right? I mean, everything should still be uploaded through JAX so that it can get pulled through that process, right? But I want to be able to prepare our team so that they know what is to come.
So I'll give a process.
Can I just, and let's also talk about non-JAX, because that's not statewide. And JAX, for folks who may be wondering, is a system that is used in Maricopa County for purposes of disclosure that isn't used in other places. So I thought it would be helpful in case somebody heard that and went, who's JAX? And why are we sending it to JAX place? So, all right, go ahead.
So initially there might be an influx, but I think in the long run there's going to be the opposite of an influx. I think it'll be less, and here's why. So they are supposed to be disclosing case notes now. They just can't do it through like the automated process the way they do the documents. And what that means is they can't see that they've done it. So I think right now they're sending a lot because they're like, I don't remember if I sent this or not, so they're sending it. But January 1st forward, they can see, oh yes, I've sent this one, I've sent that one. So they're not going to be doing these like bulk, here's everything. I mean, they may for a little bit because it's going forward, but at some point they're going to be able to tell, okay, here's what I've done here, and they can run a report and see it, and here's what I haven't. So I think in the long run, it will be less. But I also don't think it's going to be a huge influx at the beginning because they're supposed to be disclosing them, like I said, this other way, where they turn them into a document and disclose them that way. And I don't know if you see, I mean, do you see case notes on some cases? Like, you know, like a visit. I visited the parent in the home. I visited the kid in the placement. That's what a lot of them are.
We have in the past, I don't know if that's
Yeah.
this whole guardian. I don't think that's changed.
And like in a perfect world, the volume will not change because they should have been doing it just in this different way.
Yeah, I think the only caveat I would give is that because we have the ability to track it, just knowing how our employees like to have that information actually tracked in the system. What I foresee happening on January 1 is they say for those 17-year-olds that have been in care since birth, disclose every case note since birth. So I foresee that happening on day one, so it's tracked in the system that was disclosed. So I would expect an influx in the beginning.
And what that would mean is that way the next time they go, I know I disposed from birth through 17, I can start on January 2nd or whatever.
Correct.
And I mean, in some ways, this is a challenge because we don't do disclosure like in civil cases, where there's a civil cover or a cover sheet, and it goes through all the things that are attached in the disclosure, and you have it. That's being created now, but it didn't exist. So that may be that may be a big influx. It's probably going to hurt at first.
Yeah.
Just so I'm clear, there's basically going to be on all cases that are active at the time of January 1st, there should be an expectation that there's going to be kind of, okay, just to make sure we're covering everything, we're going to go back.
It's not the directive given to them. We are predicting based on like, if I'm a case manager, and by the way, we don't have any kids who've been in foster care for 17 years, so that was an extreme example. But if I'm the case manager, the case has been open for 2 years, maybe I disclose all the case notes because then I can see, oh, they've all been done. Or you could just say, okay, starting on this date, we're predicting how we think they may behave, but that is not the directive that is going out.
So it's just an abundance of caution. Who says, look, this way, when I sign that affidavit, and that's where I can see it happening. The person isn't told to do it, but they say, if I'm going to sign an affidavit, I can now really look at this and be sure.
And can I just give a quick update while we've been in here? They've finished 2 more cases. You're screwed up. Now we're at 32.
And those, again, are the appeal cases. We're not talking, and the others. In terms of have folks been able to generally agree on what's going to be disclosed at their, and I'm not going to resolve it, I said that, but have there been some things where the department's taken the position that it's not going to disclose in parents' council or children's council, thought they should get them or wanted them?
I think the only issue was with regard to foster parent licensing information. And that was not parents' council, it was children's council wanted that. But the licensing is a whole separate issue. It's not relevant to the specific case at hand. And kind of where we left it was, if there is an issue with a foster placement, child's council should know that and can say to the department, hey, I'd like background on this placement. But their licensing information is not something that would get disclosed in the case of every child that they have. So that was probably, I would say, one of our only disagreements, that I think the department's position would be that children's council is not entitled to that unless there's an issue that arises, and then that becomes relevant, at which point in time the information would be provided.
Okay. And so the disclosure, and that's part of it, is some things maybe require disclosure or again rulings from the Superior Court. I'm not here to resolve it. I just wanted to know, I heard there's a lot of transparency. I heard folks are working well together. I wanted to make sure there weren't some big glitches out there. Not that I can resolve them, but just so that we're all aware.
There's some other things. There's some other things, at least on our side, that might require a court order. We're always interested in the initial removal and what OCWI has written about the case and that sort of thing. It's also oftentimes police reports. Sometimes things have been listed as not disclosable for whatever reason. Those are the kind of things you got to take on a case-by-case basis, the way I see it. And but other than that, I don't recall that we had any major issues regarding, we want something, they don't want to give it. So we've done pretty well there.
So on the work group and the issue of the data points, I'll start with you, Mr. Foster. Where do you see us? You said something that the work group didn't seem like the best way to handle it. What are you thinking on those additional data points that we're going to be trying to wrestle to the ground?
Well, the first thing that we have to wrestle to the ground is when we say data points and what's in that computer, what are we talking about? Okay, we know some of the things we're talking about, some other things I guess we don't know what we're talking about. We've already indicated 5 different things that may or may not be data points that we believe that we need, and so it's a matter of us putting our heads together and figuring out what that is.
So in terms of that, and Mr. Hinsey, and Ms. Wright, I'm not sure who would answer this, but I thought that there was at least some disclosure of what the data points are. And has that occurred?
Yes. So the actual, I'll have Stephen explain the difference, which I think what Mr. Foster's wanting to see more is what are the fields, what are the screens that get entered? Because I think the thought is that there might be information that gets entered that doesn't create a document. So, for example, if you're putting in a referral, that screen, you're putting in the person's name, what the referral's for, that information, and it gets automatically sent out to the agency.
In the past, it would have been a referral letter, and it would have
Correct.
been nice and neat in terms of paper. But nowadays, it's an electronic.
It's an electronic version. And so I think Mr. Foster is wanting to know what are those sort of electronic items that get sent out that we would want to be able to know are there and that could have an impact on our case or could be relevant. And so those are the pieces that we haven't actually sat down and really talked about.
Okay. Action-wise, though, I think it's very similar to what we just did with the documents. We have a list and just go through them. And it takes a while, but we get it all and figure out what's the next priority beyond case notes, because there's got to be a next priority, and it's just going through this list of just shy of 1,900 tables and figuring out which ones we do next.
It's like, are you TDM notes created regarding?
TDM, they changed the TDM process, and so the notes themselves are not what they used to be. So I think that might be what folks are.
So the TDM notes are now kept on a board in the room where the TDM is. And were you at the bench bar recently? So at the most recent bench bar, the department gave a presentation on the new TDM. And so they stopped keeping exact notes and having someone write down word for word what everyone was saying, because they felt like that didn't allow for people to speak more openly and come up with real solutions, that they were so concerned about writing down the words everyone was saying that solutions weren't being met. So the notes were being kept on a board, and then sort of the decisions are being documented in the TDM report. At the bench bar, there was a lot of frustration on behalf of both children and parents council that they're not getting the information of what really occurred at the TDM. So Berka Saley from the department was going to take all of that criticism. I mean, she took notes and she asked questions back to the department to see if they can revise the form and start including some of that information back in. The intent was to have a robust conversation where people are looking at each other and talking to each other rather than everybody writing down word for word what was being said. So I think the department is probably going to be changing that again.
Well, and to that end, so we actually use a contractor to do the TDM. It's called Evident Change. They're out of California. It's kind of like, you're not supposed to say best practice, but whatever. It's like a best practice. A lot of states contract with them, and they revamped the TDM process. And I know there are a lot of feelings about what I'm about to say, so I'm just saying this. What the contractor would say is that it's not a place for lawyers. They don't want it to be contentious. They want people to say things like, I think my brother could take the kid, or I'm struggling with this, or whatever, and not have it then used as Exhibit A in court. So if you're getting pushback from the department on that, that's why, because the model says it should be collaborative and not whatever. Obviously, parents have a right to counsel, and if they want to bring their lawyer, they're allowed to bring their lawyer, but that's just a little context to it. So the model that we use is one that Evident Change uses in multiple states, and that's why we did the update to it. And so I don't know if they're going to be reaching out to the vendor and saying like, how have other states dealt with this? You know, people are upset or what.
So the answer to your question is the TDM report does not look like it used to look anymore.
Yeah.
And
I would
so
not
that might be
recognize the TDM report anymore.
right. No, and so I don't know if that's something that's being entered into Guardian or not.
Well, I know I've seen CFT notes in the case notes. And so I don't know if the TDM notes, I don't remember seeing TDM notes, but the CFT ones for sure I see in case notes.
So let me ask a question, and this may be something Mr. Foster was thinking, but if they're on a board, is there a way to document what's on the board just so that they have that piece of it?
So that was a suggestion that someone takes a photograph of the board and then that photograph becomes part of or someone takes the photograph and types it in as a case note. So those were all suggestions that were made. And like I said, Brooke Saley, who's in charge of that at the department, was very receptive to that and said she would go back and look at ways to make sure that people get that information.
Was there something that you wanted to add to that? And again, this may be something you have to talk about more below rather than here.
Well, I mean, the concept is that, well, what does the rule say? The rule says you have to disclose information about the case, right? Yeah. And, you know, on our side, if somebody says, well, we're not going to talk about this, we're not going to talk about that, or let's commit it to writing, it's problematic. It's information that we, for our case. Well, my criminal department, if they were here talking about this, what do you mean you told people not to text message? At least you had suppression. Okay, and I'm not saying that I do. And if Bill was here, he'd say, I want all the information. And I can't say I disagree with him as far as that's concerned. Because what goes on in TDM at the beginning of the case is critical. And I think we have the right to know. So whatever form it's in, whether it's, you know, was the term, not data point, but a screen, slot, whatever you call it.
Screen, where it comes up in
someplace in the computer.
This is how I log in, and that's your login screen.
Yeah, you know, for example, county right now is going through evaluations, and it's all in the computer. All right, it's got a name, and then it's got a narrative. I don't know if these referrals have narratives in it. I don't see the screen. I would guess that there are narratives in some of those documents about this case and what it's about and what they saw and what they found and what they feel. Okay, and we're done. How do they get that reduced to something that I can say, just here again, here's exhibit number 2, I'd like to have this marked of evidence. Talk about it.
I think that's why you need to, and it's going to be tedious, but to sit through and look at each screen and what are the fields in that screen and is there a narrative screen? And that's my experience. And then, all right, the narrative screen, you know, what is it said? And that's what, and I don't know, but I'm going to just, so this is completely made up. But the referral has, here's the referral, here's the person, here's this information. And there's probably some little piece that says, and here's why we're sending them over to you. That's the narrative piece.
Or here's his observation.
So, yeah, and that narrative piece is what I think you want to see whatever somebody input into that might have gone to somebody.
And I think this is something that the rule doesn't anticipate is our electronic world right now, because the rule actually says created or received. So sending a referral electronically, it may not save as something that's been created, right? So in that sense, then they would need to screenshot the screen in order to produce that. So we're going to have to look at the reality and the practicality of our electronic world when the actual rule says created. And so created means a document. And so there might not be that document. So I'm just saying we have to.
I'm not sure I would agree with that conclusion that created means a document.
Well, the rule says documents.
But
it says documents created.
Let's be careful so we don't, I get it. We're
Well,
talking over each other.
My question is, and I'm asking it honestly, like what obligates us to document a conversation though? Like if I have a conversation with a parent, we create case notes.
So that's not my argument.
Well, you
My
said,
argument is that if you do, you should get it.
Agree. And
so,
agree.
but if we have a TDM where nobody takes notes, then I don't think
But you do take notes.
on the board.
But you do take notes. And, you know, I don't want to go back to history that goes back too far. But there have been too many occasions where attorneys show up at TDMs and people say, oh, that's it, we're not talking.
Yep.
We're not going to have this. We're not going to have attorneys.
And there's been a shift in the
I
department.
understand. I understand. All I'm saying is if there's information, rule says information we're entitled to. It doesn't say in a document. It does say if you have documents, you have to disclose it. But if you got information, there's so many things that aren't documents.
There is a bit of a challenge then what isn't, and again, I'm not here to resolve the disputed issues, but it's something folks need to keep looking at. We're making a lot of progress. We're not going to resolve the universe. And that's something the lawyers get to keep working on. But how long do you think you need to go through the screenshots? This 1900, I don't know how long it takes you. Some will probably be pretty quick. I mean, I would imagine there are 1900, of those 1900, some are pretty standard. Do not even require input. It's just what is on here that was auto-populated from someplace else. Others may do things like we were talking about, the referral that actually includes information given to the provider. And that's something most people would want to know. What did you tell the person? And candidly, that's what you get if I my civil background. If I sent something electronically to an expert, I could expect that whatever I gave the expert, I have to produce because that is it. And in essence, these folks are playing that role. So it seems to me there is a disclosure that has to happen. How? I'm not sure. So if you're going to go through 1900 screens, you have a sense of what they look like much more than anybody else in the room.
Yeah.
How long do you think it's going to take to work through those with these folks?
So where it may take a day or two longer than what we did with the documents would be my guess. What I'm expecting and range of error here. So of the 1900 tables, I think we end up somewhere around 400 that people actually care about that has some substantive information in them. And I think the first bit, depending on who's all there, I'm assuming it's the same group, we'll just be getting familiar with what does this even look like, so showing the tables and explaining a bunch of things. So we'll probably start pretty slow and then catch up to speed after that. But maybe like 5 days worth of work over time.
And now of these tables are a chunk of them, for example, just auto-populated data from other places that when you've already given the disclosure, this is just how your person happens to look at it.
Right. Yes. Yes. So like a service referral has many tables that associate to it. So as we start going through it, it's not going to look like what's on the screen. It will look like a data table, and we'll just be able to point through, and I'll be able to speak through what some of the information actually is for that. But yeah, it is going to be tedious.
In terms of, and just so that I have an understanding, for example, let's say, and we use referral because we talked about it. There's a referral, and the person's filling it in. Is there a form, like a narrative place to put in on a referral?
Yes.
And does the department preserve that narrative somehow?
Yes.
And so I think that's what they're saying is they need to know what that narrative was. I don't know how it's preserved or where, but it is information that's preserved. And I don't know, you will know better than anyone how that may be able to be ported over into a system that would allow that kind of stuff. And that's, I think if you start to see what these tables look like, what data is input, then you can say, look, if they put something in there, then I need to know what did they say to tariffs? What did they say to whatever? I use tariffs just because I'm familiar with that one. And what did they say in the referral?
Yes, and the work that we're doing with the DCS notes right now sets us up for that to be able to handle it. So that notes solution, notes is stored in the exact same table format as everything else in the system. So once that gets flowing and working, that makes the next steps a little bit easier for pulling it in.
So now I know we're looking at the holidays, but I'm trying to keep my finger on this one. And in terms of next step, it seems to me we need to stay on track with your work on the January 1st deadline. You folks are going to feel a push on that one as you go. Have people come in on January 2nd and say, what happened? Brace them for that. And then know that it will ebb and flow normally after that. Then what kind of time frame are we looking at as the next steps start to come in?
So I think we can start doing the meetings on this list without waiting for January 1, because that doesn't impact my team working. That's
what I wanted to make sure. I didn't want to, again, I've got to be careful. I know everyone wants it today, but if I stop one thing,
right. Yeah, what I would expect is that if we continue meeting over the next few months or so, we can at least line up the next sort of work that we would start after February. Because that'll give us the case notes on January, and then allow for us to work through the email integration and then start on the next thing from the Guardian side to be disclosed.
So in terms of meeting, does it make sense to try and get those set over the next couple of weeks? We're in the middle of November, and I know this is a very difficult time of year. So we've got about 40-some days left in the year, and there's 3 major holidays, legal holidays, and there are a whole lot of other holidays that are part of that may not be legal holidays, but it's the time when people are very busy.
It's from Christmas.
What's that?
From Christmas.
The first Christmas, whatever you want to call it. You probably need to use your microphone, but don't do it for that one. But no, it's happening. So is it possible to meet over the next couple of weeks? Do you folks feel comfortable that you could work that in? Now, so we're not waiting. I don't want to wait till after the 1st of January to pull you folks back together to start to look at the screens.
I think between now and
okay. So let's plan on that and get those meetings set up, because then you're learning what you don't know, and that's part of this process. And you don't instantly know it. We'll get an update on where we stand after December 3rd. And it sounds like we're making progress in those cases, which I'm very happy. My judges will be very pleased to get them back, and will be very anxious to work on them very quickly for you folks. In terms of your challenge, which is once they're done with their bundles, you've got to get them redacted. And then you folks will get them. So I think we're set to keep this moving. I'm hopeful you can come close to meeting Judge Bustamante's goal that by the end of the year, we are truly at those old cases have started to get through. The disclosure has occurred. There may be more hearings at the Superior Court, but we have gotten that piece behind us. Is that a fair statement that we can do?
Yes.
Okay. And I know this puts more pressure on you folks too, so I don't disregard that. While I'm pushing down, I also know you're sitting here my parents have trials too, or my attorneys have trials too. Is that a doable date for you folks to keep working on to hopefully be in charge? And I know George, or Judge Foster, you have a different kind of issue and challenge. I was looking. I didn't give a date for the hearing, but that we're going to come back in December. But that if they meet and come close to the date for Judge Bustamante, your folks can be on top of getting your reviews done for the Superior Court, so that you can say, "Hey, think it could have won an evidentiary hearing." No, doesn't really. And I understand that some of these cases involve 1,600 pages worth of documents, so it's not a small task. Is that going to be doable for you folks?
Sorry, yeah, Steph Draper's doing the majority of it for our office.
Okay.
I'll be at these, and I want to see what the screens look like, so I'm curious about that. But we can make it work.
Okay. With that in mind, then I'm hoping when we come back in December, and I'm using it about 3 weeks out again, and I'll figure out what date that is when I log back into my computer, which keeps going in and out on. To have that happen. So 3 weeks from today would be December 10th, which happens to be this year our court is 60 years old, Court of Appeals. So shameless plug here. So it is our Diamond Jubilee, and that starting around noon that day, I'm going to have some things going on to celebrate the 60th anniversary. It's our end of year lunch that we have, and it'll be focused on that. By 2:00, I'd be free from that and could be able to meet on the 10th if folks wants to continue kind of this Tuesday tradition about 3 weeks out. And you should be at least fairly well clued into where you're at in that screen process, whether we're still on track for the January 1st, which you are going to come in and tell me that, Mr. Hinsey, right?
So I was just looking on the calendar for the.
No, that's okay. Does December 10th work? I could move it to a different day if folks wanted to. I just wanted to come up with that date.
If you wouldn't mind moving it to, I have a rather large commitment with people on
Okay.
Tuesday.
I could move it to, just see. We have an Arizona Judicial Council. I could do Monday the 9th. Is that okay? Check in the room. Yeah. 1:30. Does that work, Mr. Hanson?
Yes, it does. Thank you.
Yeah.
That's good. Okay. As we're looking for the room, because we got to make sure. We had looked at a different room, and frankly, this is, I think, the best room option. It's not available. Would you look and see if, I think you folks have access to see if 329, 330 is available. We were talking about trying to do that. But
I don't.
you don't have access to that.
If we could do later in the afternoon, I could always do later on Tuesday, like after 3:00.
I don't want to push it too late for folks only because in case, how long did we go today? We're at an hour and a half again. That's a little late. Okay. See if 329, 330. I'm going to have Patrick talk to my assistant right now because she can pull up 329, 330. Where that is it's up on the 3rd floor. It's a conference room right off the lobby. It's not quite as large as this room, but it'll be large enough for what we need to do, and we use it up there. And we've actually put in the same technology, so the whole room should work quite well. If that one's available, it'll just be in a different room in the building to try and set up. So let me ask this while he's looking that up. Some folks had talked about an issue of the redaction being overly broad. And I know you were going to look into it. And have we been able to work through some of that redaction issues and what's happened with that?
So Bill and I didn't connect, but I actually just got an email from one of his attorneys with an example, which is helpful. So I'll look into it.
Okay. If we could for the next meeting, make sure that we start to look at that. And I know your folks are doing some of the redacting now too. So we just want to make sure we redact appropriately.
Yeah, I think the concern is on the ongoing cases, not necessarily the corporate. Sorry.
Right. But it's just something that's going on, and just figured we wouldn't ignore that issue. And you're just aware you don't want to redact 17 pages with page numbers with that some issues there. All right. So we have 329, 330. So we are good there. Let's see.
In Your Honor, could I just address one issue that Mr. Foster raised about the reappointment of counsel? It has always been the department's position since the portal issue was discovered a year and a half ago that we would like for parents' counsel to be reappointed. So in every motion that we're filing on these cases, we're asking for counsel to be reappointed. We have no control over whether the court does that or not. The outerline counties are reappointing counsel. We're moving through fairly quickly. So I just want Mr. Foster to know that, like, if there is an appellate attorney, we are sending the documentation to the appellate attorney as well as the trial attorneys. We are not discriminating as to who the appellant is versus the non-appealing parent, because both parents should have had that documentation. And so that's why we're sending it out, even if you've been withdrawn, your client was entitled to that information that they didn't receive. So that's sort of what our stance has been. And so we are still advocating for parents' counsel to be reappointed because we think it's important for the parents to be able to have that voice.
No, and I'm not in charge of what the Superior Court does. Certainly, if somebody doesn't get reappointed, the one concern I think early on was it can't be reappointed for purposes of service. That is an injustice that I think nobody's really pursuing, but I know that was discussed at one point. And I think that is not happening at this point. But certainly, if someone doesn't get appointed and there's an issue, you folks we'll have to figure out how you might deal with that. And that, again, I think is below us. Not below us in terms of set the court below. I didn't want to sound like it was beneath us up here. All right. I think we've covered what we wanted to cover today. We're staying on track. I appreciate truly the amount of time people are putting into this. I think we're making a difference for the next generation of kids. And I think that's important for the next generation of parents, and allowing all the lawyers to do their job and represent people. So I appreciate it. We're going to keep working on this because we all need something else besides our day job to do. But is there anything else for the good of the order that folks want to add? I'll start on this side. Good.
Keep working.
Keep working. Keep pushing. And have a happy Thanksgiving to folks. I know I'm probably pushing you to work. I will tell you my first Thanksgiving as an associate of Lewis and Roca, I was receiving FedEx packages at the house to work on. So only a little sympathy if you have to work on the holiday, but I also don't like to have people do that. So please take the time to be with your families and enjoy that holiday as part of it. But let's keep in mind our job here in what we're doing with the juvenile court is for those families who aren't going to be sitting at our table to make sure we respect them and treat them with that dignity. Thanks, folks.